Hi there. I'm Jim Zirin. Welcome back for more conversations. The Supreme Court may be the highest court in the land, but obtains its legitimacy only from public confidence in its decisions. When it is perceived as being overly partisan or political, it loses public confidence. Since 1803, it has been the Department of Government that tells us impartially what the law is, curbing the excesses of Congress or the President, where either body exceeds the boundaries of law. At least that's the theory. Recently, it all changed. Legal commentators are the window through which the public perceives the court. And there is, in my view, none better than Stephen Vladeck, who's with us today. His book, The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, is a must-read for court watchers. His weekly Substack newsletter, One First, makes the court more accessible to us all. Steve is a professor of constitutional law at the Georgetown University Law Center, and suffice it to say, when he talks, everyone listens. We're pleased to welcome Stephen Vladeck to the program.
Thanks, Jim. I might have to carve out my daughters. They don't.
They don't. Well, they've got a lot to learn. But let's start out with the Supreme Court. It's supposed to be the highest court in the land. Many of us, many lawyers, believe it's supposed to serve as a check and balance on both the Congress, I mean, that's pretty well settled, and the executive. But that doesn't seem to be the case. What's going on with them?
Yeah, so, Jim, since President Trump came back to office in January, we've really seen this remarkable flurry of decisions by the Supreme Court not upholding the merits of any of the actions President Trump has undertaken, but clearing the way for him to continue many of these actions while litigation challenging them goes forward. And just about all of these rulings have come through unsigned, usually unexplained orders where lower courts have blocked what the Trump administration is doing or is trying to do, and where the justices are issuing what's called a stay, basically pausing the effects of the lower court ruling for the duration of the litigation, which could be months or years, allowing these policies to go back into effect, Jim, whether or not they are ultimately upheld.
Well, what accounts for the court, even on an interim basis, giving the green light to what seem to be obviously illegal actions by the executive?
Well, so part of the problem is that the court is generally not writing in these cases. I mean, even though the Trump administration has now filed 31 of these so-called emergency applications, we've only gotten 3 majority opinions from the Supreme Court across all of their rulings in these cases. So, the first problem is that we're not really sure why the court is doing what it's doing. When the court is providing even cryptic explanations, it's usually not about the merits. It's usually not because the court says, we think this is legal and the lower courts were wrong. Rather, the court has been relying on what the lawyers would call the balance of the equities, the idea that the federal government and the president in particular is harmed by being thwarted by these lower courts, by having these policies blocked for however long the litigation takes place. And, Jim, that idea is not itself novel. I think what has largely disappeared from the analysis, such as it is, in so many of these cases, is the harms on the other side, is, what harms would we cause, we, the Supreme Court, if we were to allow these policies to go back into effect, when the harm balance is basically tilted heavily toward the executive branch. You're going to see rulings like this, and I think that's a big part of what's going on.
Well, they give us really no analysis balancing the equities. I mean, where is the irreparable harm to the government if we have birthright citizenship? Where is the irreparable harm to the government if ICE stops profiling people on the basis of the color of their skin or their accent?
Or I think one that's even more illustrative is, a ruling from earlier this fall, where the Supreme Court put back into effect a policy that requires new passport applicants, but not existing passport holders, to identify themselves based on their biological sex at birth, even if they're transgender, even if they're intersex, even if they're non-binary. Jim, how can the government claim that blocking that policy causes irreparable harm when anyone with an open, active passport that refers to their gender identity, that refers to them as non-binary or as intersex, they're allowed to keep using that passport? And so I think part of the problem, without trying to get too far into the technical weeds, is that the court is almost reflexively assuming that the executive branch is harmed by any lower court ruling that blocks a policy. And whether or not you buy that, and Jim, there are good reasons not to, it's really hard to see how those harms come anywhere close to the harms on the other side, to the harms of allowing the president to, not spend $4 billion in mandatory foreign aid spending that Congress had required, to the harms to, Department of Education employees who are fired while the president downsizes that department, to the harms to, tens, if not hundreds of thousands of migrants who are being removed, perhaps unlawfully, and will have a very difficult time getting back to the United States, even if they ultimately win in their lawsuits. And so I think part of the problem is that you have a court that is seemingly misbalancing the equities and seemingly not following the precedent it's supposed to be following in these cases. And Jim, not telling us why, where maybe we're all just missing some coherent explanation here, but we have to guess because, again, the court's not writing. It's not telling us why these cases are different, for example, from the ones not involving the Trump administration, where we're seeing more of that conventional equities balancing.
And all the while, some justices attacking the judges in the lower courts for not following their directives when it's very unclear what their directives are because there's no reasoning, no guidance for the lower courts to act upon.
Well, and this, I think this was a really interesting inflection point was back in August in one of these cases about cancellations of NIH grants. You had Justice Neil Gorsuch write this concurring opinion where he called out 3 different district judges quite specifically, and he accused them, Jim, of defying the Supreme Court. That is not an accusation that the Supreme Court historically has leveled lightly. And in all 3 of those cases, it's really hard to see what the district courts did wrong, let alone how they were defying the Supreme Court. In one of the cases, there was a very close question about whether the lawsuit had to go to the specialized court of federal claims or whether it could stay in the district court. Jim, a question on which the Supreme Court itself divided 5-4. In one of those cases, the order that Justice Gorsuch accused the district court of defying had literally no explanation whatsoever. And in one of the cases, you had, a precedent from 90 years ago that the district court continued to follow because the Supreme Court hadn't overruled it yet. And it's just really striking that this is where at least some of the justices in the majority are, where rather than explain what they're doing, rather than explain how they reconcile what they're doing with what they've done in other cases, they're more inclined to attack lower court judges for failing to read their minds. And Jim, I don't think it's a surprise that in response, we have seen really a unprecedented number of public criticisms of the Supreme Court from these same lower court judges who are basically saying, what do you want us to do? We're not trying to defy you, but we also don't know what we're supposed to do when you issue all of these rulings without telling us what you're doing and why.
Well, when the Supreme Court fires a shot, it's heard around the world. Mark DeMazer of the BBC, writing in the New Statesman, says, quote, Trump has crushed the great institution into an impotent partisan mess, end quote. You think that's a fair statement?
So I guess, for all that we've been chatting about, so far, I think it's probably still a bit too early to tell. I think it is certainly true that the court to this point, as you and I are sitting here, has shown very little interest in pushing back against this administration. Jim, with one exception, about the Alien Enemies Act, this case from April. But I also think it's possible that some of the most important justices in these cases, whether it's Chief Justice John Roberts or Justice Amy Coney Barrett, don't see these emergency applications as the referenda on the Trump administration that folks like you or I do, and actually think that whatever they're doing in these cases is not necessarily going to predict or should control how they rule on the merits. And so, it's only just now that the Supreme Court is first getting to the merits, getting to full plenary review in some of the cases challenging President Trump's policies. The tariffs cases were the very first ones. Those were argued back in November. December is going to have the oral argument in the Slaughter case about the president's power to remove members of the Federal Trade Commission. And so, Jim, it's possible that by the end of the court's current term next summer, we'll see more pushback from the justices. The problem is everything that's happening in the interim, that even if, when push comes to shove at the end of the day, we're seeing the court actually draw some lines, by granting so many of these emergency applications, the court is allowing an awful lot of harm, and I will just say from my perspective, damage, to occur in the interim, most of which is not going to be reparable. So, I don't know how you unring the bell, for example, of completely dismantling the Department of Education, something the Supreme Court has allowed the president to do through one of these orders. I don't know how you unring the bell for all of the transgender members of the military who were kicked out, right, and who had to go find other lines of work, who perhaps had to relocate. I don't know how you unring the bell for the countless thousands of migrants who have been removed, in many cases to countries with which they had no prior connection. And so it's possible, Jim, that, a year from now, 2 years from now, 5 years from now, the story of how the Supreme Court checked the Trump administration looks somewhat more equivocal and balanced than it looks as you and I are sitting here. The problem is that even if that's true then, we can't ignore and we can't sort of wipe away what has happened to this point.
But reading the tea leaves, you take the transgender decisions on the passport case and the military case. Doesn't that augur poorly for transgender rights if they ever reach the merits on that issue?
It may well. And actually, the court already has cases this term about discrimination against transgender athletes, so we might know more. The point is not, I think, that anyone should think it possible that the court's going to rule against Trump in all of these cases. I think the question is the court going to rule against Trump in any of these cases? And I'll just say that there, I think the answer is probably yes. I think that, the birthright citizenship cases are going to end with a loss on the merits for the Trump administration. I think there's still a good bet that tariffs cases do as well, and perhaps some others that are on their way up to the Supreme Court as we speak. But, I think there are going to be folks who are sort of quick to defend the court, who point to any rulings like that and say, look, the court is actually doing its job. It's serving as a check on the executive branch. And my response would be that I think you really have to account for all of these emergency applications, even if the story becomes a little more complicated by what happens on the merits. And the emergency applications are a problem, not because they're legalizing what the Trump administration is doing, but because they're enabling it. It's not just that the court is putting back into effect policies that lower courts blocked. Jim, it's that these rulings are also telling the executive branch that it can be even more aggressive in some respects. Back in September, we had the ruling by the Supreme Court in the Los Angeles ICE raids case, where the court, paused a district court temporary restraining order that had stopped racial profiling by ICE. Well, Jim, you don't have to look far to see media reports that within days, if not weeks of that ruling, ICE started becoming even more aggressive in our cities, pulling people over, taking people out of their places of work, out of their homes. I don't think that's a coincidence. And so, I think we have to be sort of careful to distinguish between the short-term role the Supreme Court is playing, which I think has been quite alarmingly uncritical and unchecking of Trump, and the role it might be still inclined to play in the medium and long term, which could be more ambivalent.
Where in the Constitution, Steve, do you find authority for the court reining in executive power when it goes off the rails?
I think this has been an understanding that's baked all the way into the court's jurisprudence back to, Marbury versus Madison. If you buy the notion that the Constitution gives the Supreme Court the power to interpret the Constitution simply by giving it jurisdiction over cases arising under the Constitution, then that doesn't change whether the claim is that a statute is unconstitutional or that an executive action is unconstitutional. If anything, we might even want the court to be more skeptical of executive actions, which have not run the gamut of the legislative process, which have not required compromise and majority votes of two different democratically elected chambers, but could really just reflect the whims of one person. So historically, Jim, the court has been more deferential toward statutes than toward executive branch actions. One of the real oddities of what's happened over the first 10 and a half months of the second Trump administration is that presumption in some way has flipped. That the court is giving all of this deference to the president, even in cases in which he is defying statutes, where one would think that any kind of deference or presumption should run in favor of the statute, not the executive order.
Well, it's quite a shift from Trump 1, isn't it? Where we really didn't have these issues arising. Do you think it's there was an intimation by Trump at the outset that if he didn't like some decision of the Supreme Court, he'd feel that he was free to disobey it? If that happened, it'd probably be a constitutional crisis, whatever that means. And do you think the court is wary of a constitutional crisis, and so by giving in to Trump, the issue was at least kicked down the road?
I'm sure that's part of it. And, some of the court's more savvy public defenders have suggested that maybe part of what's happening in these cases is appeasement, where Chief Justice Roberts is sort of holding his fire and saving the court's capital for more head-on confrontations on the merits of these cases. The problem I have with that, Jim, exactly. The problem I have with that is whether or not this is, Munich in 1938. One of the things that appeasement does, right, is it enables the aggressor to be more aggressive. And in the interim, you have the continuing costs, you have the continuing harms that are wrought by all of that. And so it just seems to me that, like, if the Supreme Court is going to draw a red line, I would have thought it would have done so by now, but certainly in some of these merits cases that are coming up soon. Because what we're really seeing is this remarkable difference from the first Trump administration, where during that administration, Jim, the president was subject to a whole bunch of constraints from Congress, even when there was Republican control, and from his own internal bureaucracy. Now, both of those constraints are gone, and everything has become just sort of what can the courts do versus what can't the courts do. And at least so far, the lower federal courts have been a huge part of the story. I mean, as of the end of November, there had been more than 150 cases in which lower federal courts had issued, some kind of injunction or coercive relief against a Trump administration policy. That's a really striking number, even accounting for the 22 or 23 of those in which the Supreme Court granted stays. The majority is still blocking. But that, Jim, is not a long-term solution. That's not a long-term way of preserving the separation of powers. If anything, it's a holding action. And I think the question is going to be, what gives? Does the Supreme Court really start to assert itself more? Or are we going to see more and more rulings like what we've seen to date, where the court is largely getting out of the way for the Trump administration to do whatever it wants? Jim, some of that may just depend upon the polls and how popular or unpopular the president continues to be.
Well, one wag said at the turn of the last century, the Supreme Court follows the election returns.
I've always thought that line was sort of missing the other part of the quote. Dooley didn't have another quote, but that I think it's a half step more complicated. So Paul Freund had a version of this where he said, the justices should not be following the weather of the day, but they should be sensitive to the climate of the era. And it seems to me that that is the real question, which is how much are the justices sensitive to the climate of the era, a climate, Jim, in which the judiciary really has become the principal check on, what at least from my perspective is unprecedented lawlessness by the executive branch. And I think, at least to this point, that check has been robust, even with the Supreme Court's interventions. But without a little more of the Supreme Court's involvement directly, I worry about how much longer that can be sustained.
Well, the behind you on your bookshelf, I saw it says Star Wars, and the executive branch in the person of Todd Blanche, the Deputy Attorney General, has declared war on the judiciary. When in our history has the Department of Justice declared war on the federal judiciary?
What's striking about the Deputy Attorney General's comments at that November conference is not just the sort of war visibility and the war idea, it's that he's not alone. I mean, President Trump has called for the impeachment of judges. Attorney General Bondi has filed what's basically a frivolous misconduct complaint against the chief federal district judge in D.C. Stephen Miller, every time a judge rules against the administration, calls them part of the legal insurrection. And what's striking about this, Jim, is sort of both the input and the output. What's causing all of this? Well, the reason why we're seeing these attacks is because the judges are actually doing their job, is because the judges, especially in the lower courts, actually are standing up to the Trump administration. But these attacks are not just unprecedented, they're very dangerous because they reflect, at least to me, a pretty obvious intent to erode public faith in the credibility and the legitimacy of the courts. And they pose a physical threat to many of these judges who have been subject to, doxing, to having pizzas sent to their, unlisted private home addresses in the name of the dead son of a federal judge. And it's really, I think, an escalation that drives home both how important the courts have been so far in holding the Trump administration accountable, but also how fragile that is and how much, the Supreme Court, I think, is doing no favors by not getting the backs of these lower federal courts, but also not telling us why.
Well, in 1802, with the failed impeachment of Justice Chase, I thought that it was settled that we don't impeach judges for their decisions, however erroneous. We might impeach a judge because he's insane or he's drunk or he took a bribe, but certainly not for their decisions, and certainly not for a disagreement with their politics if their decisions do express a political point of view.
And the Chase precedent had lasted for 220 years. I mean, we've had, 13 federal judicial impeachments since Justice Samuel Chase, and all of them have been for the reasons you identify. We don't impeach judges we disagree with, you appeal. I mean, that's the way our legal system is supposed to work. And if anything, Jim, our whole conversation about the Supreme Court, I think, reinforces that this administration has been able to get the relief it has wanted from the Supreme Court, perhaps in more of these cases than it should have. So I think what we're seeing is, an unprecedented assault on the federal courts at a time when they have been the most effective check on the executive branch. And I don't think for a moment that those two things are unrelated.
Do you believe the Supreme Court is a political court, unlike the lower federal courts?
So, I mean, yes, but Jim, I think the court has always been political. I mean, right, going all the way back to, Marbury versus Madison is a deeply political decision. To me, the issue with the Supreme Court is not that it's political. The issue is that I think it has increasingly become unaccountable. Part of being a political institution in our system is that you have to look over your shoulder every now and then, that you're subject to checks, that you are, mindful of the role of the other institutions in our system. And I think what we have today in Washington is a Supreme Court that is not accountable to the other branches of government and doesn't think it ought to be. Justice Alito gave a quote to the Wall Street Journal in July of 2023, where he said, no provision in the Constitution allows Congress to regulate the Supreme Court, period. That's literally incorrect. Article 3, Section 2 gives Congress the power to, quote, make regulations, unquote, of the Supreme Court's docket. So I think, the problem is not that the court's political. The problem is that the court is completely sort of aloof from the sort of normal push and pull of our political process. And it's in a position where it can do whatever it wants without much fear of reproach. That, I think, is something that is part of how we got to where we are today. And I think that's really the big thing that we would need to fix going forward to make the court a healthier part of our constitutional system. And Jim, frankly, I think to put the court in a better position to be able to stand up to any president, Republican or Democrat, when it comes to enforcing the Constitution and the laws.
Okay, there's so much more we could go into, but we've come to the end, sadly. But I have a question for you, Stephen Vladeck, and the question is, do you think this Supreme Court will ever rein in the excesses of Donald Trump? Do you have hope?
I have cautious optimism that this court will, in fact, find at least some things that the Trump administration is doing that it won't approve. I worry that it won't be enough. I worry that it will be too late. And I worry that it will not be sufficient to undo the harms that its interventions to this point have already caused. But, that is, I think, at least the bare minimum we can and should expect from the Supreme Court.
Are we on the road to autocracy because the court is reluctant to assert itself?
I mean, I don't think it's that controversially we're on the road. How far down the road we are and how many exits are still left, I think, is the fight. And I have faith that this Supreme Court, if it's invested in nothing else, Jim, is invested in preserving its own power. And so there's going to come a point where that means ruling against the president, even if it's not in the cases I would want or for the reasons I would want. It stands to reason that one way or the other, self-preservation, if nothing else, is something this court will be invested in.
Self-preservation is the ultimate answer. So, Stephen Vladeck, thank you so much for coming by. This has been just marvelous. Thank you for coming by. Tune in next week for more conversations. Then don't forget to download our app, the CUNY TV, and you can listen to this program and other great programs when you're at home or even on the road. I'm Jim Zirin. Take care, be well, all the best.